This is item number 22, AB 2813. Yes.
Good afternoon. Foster youth are among this state's most vulnerable residents, especially when it comes to the juvenile justice system. Foster children are often more unfairly and disproportionately detained for minor misbehavior. Even brief detention in juvenile hall has been shown to decrease education and employment outcomes and increase the likelihood of a minor coming into contact with the criminal justice system later in life, an outcome we all would hope we can avoid. This bill seeks to protect foster youth by ensuring that probation's detention and release decisions are not based on minors' foster care status. The bill does a number of things. It prohibits probation officers from considering a minor's status as a foster youth or current availability of placement when making the decision whether or not to detain. And it also requires probation officers to immediately release a minor to the custody of child welfare services, a caregiver, or a foster parent, unless it can be demonstrated that the minor's detention is necessary. For example, if the minor were to be determined a danger to himself or others or a flight risk. Several years ago, the state enacted legislation to ensure that a minor's status as a foster youth not be used during the detention hearing stage as a reason to detain that minor. This bill will simply apply that same principle to the probation officer's decision to detain. AB 2813 will harmonize the detention criteria used by probation with those used by the court at the detention hearing and create a set of equitable detention standards for foster youth. With me, I have Virginia Corrigan from the Youth Law Center and Carolyn Levenberg from Dependency Legal Group in San Diego.
Thank you very much.
Thank you, Madam Chair and Assembly members. My name is Virginia Corrigan. I'm an attorney with the Youth Law Center in San Francisco. We are a nonprofit legal center that advocates on behalf of youth in out-of-home care. We are proud to sponsor this important bill, and many thanks to Assemblymember Bloom for his leadership on this issue. AB 2813 seeks to limit the detention of foster youth to situations where it's truly necessary and only to situations in which any other youth would also be detained. This is important because the harms caused by even a short stay in detention are serious. Research has demonstrated that juvenile detention exacerbates behavioral problems and pushes youth even further into the delinquency system. And the risk is especially serious for foster youth, as foster youth who cross over into delinquency experience significantly worse outcomes than other groups of former foster youth. AB 2813 is an important step to ensure that foster youth are not unnecessarily and inequitably subjected to the harms of detention. Another important goal of this legislation is to update probation detention standards. In fact, much of the portion of the statute that outlines in which situations it is appropriate to detain a young person have not been substantively changed since 1967. But juvenile justice practice has changed since then, and probation departments no longer base their detention decisions on such outdated considerations as whether a youth has a physical deformity or whether the youth is destitute. It's time that the statute be amended to reflect current probation practices, and AB 2813 would accomplish just that. I respectfully request your aye vote.
Thank you. My name is Carolyn Levenberg, and I am the supervising attorney of the Dependency Legal Group in San Diego. We are court-appointed counsel for minors who come into foster care in that county. I'm also a lecturer with the San Diego State School of Social Work. I teach social policy and also child welfare. I have 15 years of experience in child welfare, and I also appear on the dual calendar for the last 5 years. And I'm here as a practitioner to tell you that this is a real problem. It's a real problem for youth who are being detained at a disproportionate rate. I strongly support AB 2813, and I'd like to add that it doesn't confer a benefit to foster youth. It merely gives them equal footing, and it assures them equal protection under the law. As a practitioner, I have noticed a number of kids who have been detained who have been detained and would not have been detained but for their foster care status. For example, a 13-year-old client who was caught stealing $4 worth of merchandise from the dollar store was detained. The probation officer did not have this statute to rely on. That youth was detained for quite some time, while an adult who was also arrested for the same offense was cited and released on the spot. A second client that we had was also 13 and arrested for vandalism. She essentially was taking chips out of a vending machine. She again spent significant time in custody because probation did not again have this statute to rely on. And again, we would ask you to support it. It does not confer a benefit, but again, just put these kids like every other kid and puts them on equal footing. Thank you.
Thank you very much. Those in support, name and organization.
Rebecca Gonzalez, National Association of Social Workers, California chapter, in support. And I was also given permission to express the support of the Children's Defense Fund.
Thank you.
Martha Matthews, Children's Rights Project and Public Counsel. We were the primary sponsor of Assembly Bill 388, and we strongly support this bill, which closes a gap in the prior legislation.
Thank you.
Susan Abrams with Children's Law Center of California also strongly support this legislation. Thank you.
Susanna Niffen with Children Now in support.
Anyone in opposition? Seeing none. Any questions from the committee? Seeing none. Okay, we have a motion and a second. Would you like to close?
I ask for your aye vote. Thank
Thank you
you.
very much.
Bonilla.
Aye.
Bonilla, aye. Grove. Calderon. Lopez. Lopez, aye. Mainshine. Stone. Stone, aye. Thurmond.
Thank
Bill
you.
needs one more.
We need one more. Thank you very much.
Thank you.
Thank you.
Looks like we need Ms. Lopez to present. We don't have any other authors, correct?
Right.
Okay, thank you.
Just going to get your sponsor.
Okay.
Okay, we have item number 8. This is AB 2036.
Okay. Good afternoon, Madam Chair and members. Today, pleased to present AB 2036, which would require online child care posting service to provide the following information. 1, to provide register in California trust line register, and 2, to provide a give prescription to the information, include the background check take by nanny or babysitter. With me today, I have Cindy Mo from the California Child Care Resource and Referral Network to testify and answer any question. Thank you so much.
Thank you. Thank you. Good afternoon. My name is Cindy Mall. I'm with the California Child Care Resource and Referral Network. Our organization is listed in statute with certain responsibilities related to administering the trust line background check. We do that under contract with the State Department of Social Services, so we've had a lot of experience since 1992 with background checks, and especially in child care. And, when you think of a background check, the best kind of background check is one that looks at a lot of different types of data. And the trust line background check includes data that's searched by fingerprint at the Department of Justice, and it includes criminal convictions and child abuse index and an FBI check. And it looks at all counties in the state of California, and it's continually updated. And so when you look at background checks, and as a parent who's choosing a child care provider, we really should know what resources exist for us in the state of California. And going to the online job posting websites, they do say that there's a background check done. But when we think about background checks, we make assumptions about what they include. Whether it's a background check for a Little League or Boy Scout leader, we say, well, what does it really include? And it's hard to tell. And so when we found out, we were very surprised to find out that one of the online background check services, they actually post what they check and they don't check. And they say we do a background check, and their basic background check checks 29 of California's 58 counties. It does not include information or criminal history information from the counties of Stanislaus, Solano, Tulare, and San Joaquin, among the other counties. And we don't know what they check. And so when you look at what they actually check, and you look at the city and county of San Francisco, the county of San Francisco, the only thing they check there is the most wanted list. So they don't check for criminal convictions of felonies and misdemeanors for San Francisco County and those other 29 counties. We feel parents should have the information available to them on the website and also know about the California resource to choose their child care provider and protect their children.
Thank you so much.
Thank you.
In support? Anyone else in support? Any opposition? Do we have support? Okay,
Yes.
thank you.
Jennifer Greppy with Parent Voices California and our 15 chapters across the state absolutely support this bill and the safety of our children. Thank you.
In support?
Kevin Esner, Coalition California Welfare Rights Organizations, in strong support. Thank you.
Thank you. Any opposition? Seeing none. Any questions from the committee? Seeing none. Would you like to close?
Yeah, I respectfully ask for your vote.
Thank you. We have a motion and a second. Okay, we need to vote on the bill, actually.
Bonilla.
Aye.
Bonilla, aye. Grove. Calderon. Lopez.
Aye.
Mainshine. Stone. Stone, aye. Thurmond. Bill has 3-0.
All right, thank you. We'll keep it open.
Thank
All right,
you.
Mr. Alejo's up next. Thank you very much.
I also gave notice to Mr. May's office. I gave notice to Mr. May's office as well. Mr. Yep. And Mr. Alejo's been contacted by the sergeant and his committee and also by his staff to say we need him now.
And we just want to go look for him again. Can we put his head in there?
Yes.
Just call over there and say, see chair over there, but
Yeah.
call you guys come up, or you're open right now. I need you here.
Jesus.
And Mr. Mays has been called. And where's Mr. Calderon?
He's presenting. He'll be here as soon as
He's in hell. Okay. Right now. We're waiting.
Okay, very good. She messed up.
I'm sure would you like some? Okay. He's not leaving. Calderon and Mays.
Calderon's presenting. So I'm gonna find out the size.
Let's see. We're number 3. Okay, this is a due pass to appropriations, and we have a motion and a Ms. Lopez seconded. And it's looks like number 5. Oh, we did. That's moved. Okay. Number 8. That's already 10. We haven't heard 10. 12.
AB 2150. So moved.
All right, we have a motion due past to appropriations and a second. This is on number 12. Santiago. Item 12. We did Main Shine's bill, right? Holden.
So moved.
Due past to appropriations. We have a motion and a second. So Stone.
Item 172552.
Wait a minute, I'm confused here, I'm sorry.
We're just doing motions and seconds so you can get them written in.
Oh, I see. Okay. It's done. All right, motion and second. We're not calling vote.
Right. We're going to have to add everyone on anyway. Number 19.
So moved.
Motion. Okay. Number 20.
So moved.
Due past to appropriations. Who's this? Oh, really? Okay, Mr. Alejo. Welcome, Mr. Alejo. You ready to present AB 1770?
Madam Chair, if I could do AB 2380, I have a witness that has to hit the road, District Attorney.
Certainly.
Thank you very much, Madam Speaker. This is AB 2380. Today we are here to present this bill regarding background checks for custodians, informal caregivers of children whose parents are incarcerated for lengthy terms. I do want to say, first of all, that I'm willing to accept the amendments that we worked out with staff last week that are included in the bill analysis, and I want to thank your staff for the gracious assistance in crafting this proposal. This bill is certainly about protecting children. I was moved to author this bill after the recent tragic deaths and torture of a 3-year-old, Delilah Terra, and her 6-year-old brother, Sean Terra, and the torture of their 9-year-old sister, who are from my district in East Salinas. This occurred 4 months ago in December 2015. Authorities found the bodies of a 3-year-old Delilah and 6-year-old Sean in a storage container in Northern California. The children had been in the custody of Tammy Huntsman, an informal caregiver who was designated by their father. The father had been sentenced to a long prison term, and the children's mother had been deceased after, I believe, a car accident. Huntsman had since been charged with the children's murder, and the case is currently being prosecuted by the Monterey County District Attorney. But after researching the law regarding the custody of children of incarcerated parents, we discovered that the current law fails to provide basic protections, oversight, and safeguards for our vulnerable children in situations such as this, where they only have one parent in the home, and that parent is incarcerated for a long period. Ensuring the health and safety of our children is one of the most essential roles of government, and our system failed 3-year-old Delilah, and it certainly failed 6-year-old Sean. The amended bill requires the court, at the arraignment of a parent who is charged with a felony and who is the sole guardian of his or her child or children, to provide that parent with information on options regarding the provisions of care for his or her child in the parent's absence, including ways in which to formalize the relationship with the person with whom he or she is entrusting the care of his or her children, such as appointing the power of attorney and the availability of services to research a potential caregiver's background. This amendment addresses the constitutional issues regarding parental rights raised by the committee staff. The bill would leave it up to the parent to decide whether or not to pursue a background check for the chosen informal caregiver. But it is clear from this Salinas case that had there been at least something so basic as a background check, the parent, perhaps others, would have been informed of this particular informal caregiver's past history of child abuse. This would empower other parents to learn more about the people that they are entrusting with their children. It would use the existing trust line system, which is administered by the Department of Social Services, to run a background check. If the chosen informal caregiver is approved, they will be listed on the easily accessible database, both by phone and online. This will allow parents to have the information they need to determine if the chosen informal caregiver is an appropriate person to care for their children. With me here today to speak in support of this bill is Ms. Janine Passioni, representing the Monterey County District Attorney, who is currently prosecuting the Huntsman case. I respectfully ask for your aye vote, and as this bill will move next to Public Safety Committee. Thank you, Madam Chair.
Thank you very much. Thank you for joining us.
Thank you. My name is Janine Pacioni, I'm the Assistant District Attorney in the County of Monterey District Attorney's Office. We are currently prosecuting this case. The children were actually found in Reading, but they were tortured and killed in Monterey County. We were able to determine that. We've got a 3-year-old and a 7-year-old and a 9-year-old, all three of whom were tortured. The 2 younger siblings, they in fact died and then were placed into a container and put into a storage container in the Reading area. The defendant in this particular case is, in fact, an informal caregiver, which when the bill was originally provided to us and we signed on for support, we were very much supportive of the fact of background checks for informal caregivers. We understand the amendment's been made and we continue to support the bill. We believe that education in terms of informing the defendants of their rights and possible options for having backgrounds provided for informal caregivers is a positive move, and of course education is never a bad thing, so we would continue to support that.
Thank you very much. Others speaking in support of the bill? Okay, anyone in opposition?
Susan Abrams with Children's Law Center of California. We did submit a letter of opposition, but we withdraw our opposition based on the amendments, which are very sensible approaches to a big issue and protect children. Thank you.
Thank you.
Robert Stevenson with Ladle. We had initially strongly opposed this bill, but based upon the amendments and the considerations that the author has done at this point in time, we would support the bill going forward.
Thank you.
Martha Matthews, Public Counsel, Children's Rights Project. We also had the same concerns as the Children's Law Center. We would withdraw our opposition in light of the amendments that the committee suggested.
Thank you.
Jennifer Rodriguez, Youth Law Center. We did also oppose this legislation, but would withdraw our opposition in light of the recent amendments.
Thank you. Any questions from the committee? Seeing none, would you like to close?
Thank you, Madam Chair. This is a work in progress. We're trying to refine the process, trying to find a better way to protect children. If you could imagine in this case where their mother had passed away, their father was going to be incarcerated for several years. And then when we looked at the statutes, you looked at the process, you found out that there really is no protection for these kids. If they're left with a friend or relative, regardless if they have a past history of child abuse, past history of sexual abuse, there's no way to inform that parent or look after these children. This horrible case where kids, the most innocent and vulnerable, were tortured and murdered, brought this to light, that there is really no safeguards in this situation. So we're trying to find a way to protect our kids, of course, and better inform the incarcerated parents of their options, especially in light that somebody might have red flags. But having worked previously in the family law court, whether it was assisting the judges in probate court with the guardianship, or whether it was suspected crimes or history that called into question a parent or a custodian's ability to take care of children, the courts had major safeguards. In the probate court and guardianship cases, there's a thorough background. The court investigator go visits the home. They even do background checks, not only on the potential guardian, but every other adult that lives in the house. There's a very thorough process in other types of cases. But when it comes to the children incarcerated, there's very little safeguards. And so, yes, I had to make some amendments trying to make sure we keep the bill moving forward and address some of the concerns from this committee and the opposition. But ultimately, we're trying to find a way that hopefully, when in these very limited cases where the only remaining parent is being incarcerated, that we can have a process that could at least do the very minimal, the very basic safeguards in doing these background checks, so that red flags could be raised if a potential informal custodian does have serious felonies in his record, or child abuse in the past, or physical abuse. There's a way that could be brought to light and that information given to that parent, so that hopefully that would inform and perhaps change the informal custodian, and hopefully avoid these kind of cases that should never, hopefully never happen again in our state. With that, Madam Chair, I respectfully ask for your aye vote on this important bill.
Thank you very much, and I do think that it will make a difference to inform the parents of their rights, the opportunities to do background checks. I imagine it's an incredibly stressful time for the parent who's facing the criminal charges, and that this could really prod them in that direction of looking after their child and ensuring that their child is in safe hands during that incarcerated period. Thank you very much. With that, do I have a motion? It's a do pass as amended to public safety. We have a second and a motion and a second. Thank you very much. Take the roll.
Bonilla.
Aye.
Bonilla, aye. Grove. Calderon. Lopez. Lopez, aye. Mainshine. Stone. Stone, aye. Thurman. Thurman, aye. And the bill is out.
Great. Thank you very much.
Thank you very much, Madam Chair.
All right, we'll go back to item number 1, AB 1770. Thank you.
Madam Chair, this is AB 1770, which seeks to expand the CalFresh system to ensure that any person who is lawfully present in the United States has equal access to nutritional assistance. This bill will finally fill in the gaps caused after the federal welfare reform in 1997, which restricted the eligibility of some immigrants in our country to access the social safety net. In response, we as a state expanded eligibility to CalFresh to include some immigrant Californians who were made ineligible by the federal welfare reform. And as a result, most immigrant Californians have access to food assistance under either the federal SNAP or the state CalFresh programs. But not all immigrant Californians who work and pay taxes like the rest of us qualify. Immigrants granted deferred action under the President's executive orders are ineligible for food assistance. This is also true for longtime California residents who are applying for legal permanent residency status under certain programs. AB 1770 will reduce hunger in our state by making an individual who is legally present in the United States eligible for CalFresh benefits. Specifically, this bill will expand CalFresh to include DACA recipients, residents here under temporary protected status because of conditions in their home countries, or those applying for permanent, legal permanent residency status. Not only is this the moral thing to do, but it's also financially prudent action to take today. Expanding access to CalFresh to all immigrants legally present in the state will spur economic growth here. In fact, according to the U.S. Department of Agriculture, every $5 in financial assistance generates $9 in economic activity. This bill will not only make California a more just state, but it will show that all Californians are equal in the eyes of the law, regardless of whether they are Californians by birth or by immigration. I respectfully ask for an aye vote, and I have some advocates who speak in support, Madam Chair.
Welcome.
Good afternoon, Ronald Coleman here in support on behalf of the California Immigrant Policy Center. AB 1770 essentially solidifies the work that California started in 1997 after welfare reform passed at the federal level. Certainly, California did what it needed to do and really ensured that lawfully present immigrants could still benefit for the CalFresh program, specifically through the California Food Assistance Program. All this bill does is really update our existing laws to ensure that statuses that were not available before are included in our eligibility for this program. Certainly, it couldn't have been foreseen that these new statuses were going to be developed by the federal government over the years. So what we'd like to do is just ensure that these individuals who are tax-paying, work authorized, are absolutely able to receive food benefits when they need them if they have an unfortunate event or circumstance in their life. We have testimonials that I think may have been passed around, but essentially one individual, Janeth Nava, she is an immigrant and was brought to the United States when she was 9 years old. She has a U.S. citizen child, and that U.S. citizen child allowed her to have eligibility through him for CalFresh, but certainly not eligibility for herself, being a deferred action approved individual through the DACA program. We also have Carlos Gomez, who has temporary protected status, who is not eligible for food benefits either. And this individual, because of the lack of access to fresh foods and vegetables, actually had been growing vegetables and different types of plants to eat in his house, in buckets and baskets and trash cans, etc., all over, anywhere he could find places around in his house to be able to grow fresh food so that he could have the sustainable nutrition. So, you know, we want to give all Californians a sustainable quality of life, and we believe AB 1770 allows them to do that by getting food benefit eligibility. Thank you.
Thank you.
Good afternoon, and thank you, Madam Chair and members. My name is Carly Finkel, and I represent the Food Bank of Contra Costa and Solano, which serves the Chair's district and parts of Assemblymember Thurman's district. The Food Bank of Contra Costa and Solano distributes 20 million pounds of food each year, and our organization serves 1 in 8 people in our 2 counties, 1 in 4 of whom are children. Our organization also worked closely with the county to conduct CalFresh outreach to help raise awareness and participation among eligible individuals. However, many of the rules around immigrant eligibility are confusing, both for the applicants and for our outreach workers. Updating our definitions to reflect all existing immigrant categories will simplify and streamline our outreach work and allow legally present immigrants to receive the benefits that they deserve and need to get back on their feet. A full third of CalFresh recipients in California rely on food banks in addition to the nutrition assistance that they receive. Many of our clients struggle to make ends meet by piecing together various forms of public and private assistance during times of struggle, and we are just one piece of the support network, but we've grown a shocking amount since the economic recession in an attempt to fill other growing gaps in the safety net. The number of people that we serve each month has increased by 74% since the depth of the economic crisis in 2008 and 2009. The food bank now serves 190,000 people each month, significantly more than the 116,000 people that are enrolled in CalFresh in our 2 counties. Food banks are intended to help people make it through times of emergency, the loss of a job or unforeseen medical expenses. We're meant to work in tandem with CalFresh, not replace it for people who would otherwise qualify for nutrition assistance but happen to fall into immigrant categories that didn't exist in 1997. The Food Bank of Contra Costa and Solano respectfully asks that you update the California Food Assistance Program eligibility requirements to ensure that all legally present immigrants are able to qualify for CalFresh benefits. Thank you.
Thank you. Others in support?
Kelly Brooks on behalf of the County Welfare Directors Association. We're very pleased to be here today in support of AB 1770.
Thank you.
Raquel Campuzano from the Western Center on Law and Poverty, a co-sponsor of this bill in support.
Jeanette Sanipatin on behalf of MALDEF, the Mexican American Legal Defense and Educational Fund, also in strong support.
Thank you very much. Anyone in opposition? Seeing none, any comments from the committee? Seeing none, would you like to close?
Respectfully ask for an aye vote, Madam
Thank
Chair.
you so much. We have a motion and a second by Ms. Lopez. We'll take roll.
Bonilla?
Aye.
Bonilla, aye. Grove? Calderon? Lopez? Lopez, aye. Mainshine? Stone? Stone, aye. Thurman? Thurman, aye. Bill is out.
Bill is out. Thank you very much.
Thank you very much, Madam Chair.
I think we'll go ahead and start voting.